equal in that phrase, and that's an important part of the phrase, of course. But also, created is. It means that we all start on an equal ground. And what you do with your life is up to you. You are supposed to be able to make your own life as you go through it. You're created equal. It doesn't mean everything in life comes out equal. And what the left is trying to do is implement this sort of outcome equality, if you will, that honestly at this point doesn't even seem equal. Like they're trying to punish stuff that, I don't know, somebody's great-great-grandfather did that I had nothing to do with. I had nothing to do with slavery, Megan. I promise you. I have no slaves on my plantation in my cul-de-sac. That's not something I'm engaging in, and nor would I want to. And thank you. And I will say, if you legalize slavery today, people would not want to engage in it because they know it's abhorrent. Right?
I think P. Diddy wants to engage in it. I beg to differ. I think Puff Daddy has been engaging in it for quite some time based on the testimony I'm hearing. But keep going.
You're 100% true on that.
Because it's 9-0. Both of these two decisions in which we're interested today are 9-0. One was written by Ketanji Brown Jackson and one was written by Sotomayor. And you and I will like both of them. How about that? You know, the court is always saying most of their decisions, the vast majority, are actually unanimous. It's, you know, a small handful that wind up 5-4 and give the Supreme Court, you know, this controversial reputation and makes leftists say we have to delegitimize them and stack the court and all that stuff. But anyway, this is 9-0. It's Ames versus Ohio Department of Youth Services. And this was a so-called reverse discrimination case where a straight woman got effed over by her boss in favor of a gay woman who she said was less qualified. And when she sued over it, saying that's reverse discrimination, you can't discriminate against me because I'm straight. The courts in Ohio within the 6th district said, okay, you can file this claim, but you're going to be held to a higher standard of proof because you're straight. Because generally there's a presumption in the law that people don't discriminate against people who are part of the majority group. So you have to prove more than a gay person or a minority, a person of color, et cetera, would have to prove. You have to prove, for example, that there's a history of this employer discriminating against straight people. So like you have to show statistical, you know, proof that majority members continuously get discriminated against by this employer. And she said, that's bullshit. That's not fair either. Like that too is discriminatory against straight people. And 9-0, the high court agreed with her. And what this decision effectively does is lower the burden of proof that people in the so-called majority group, here it's a straight person, could also be a white person, could be men, et cetera, people who are not considered part of any protected class, now have to meet in order to bring what we used to just call reverse discrimination claims. This is great. Your thoughts?